Alright, live from the seacoast of western Tennessee. It's another day of adventures in legal land time. It's December 11th. 8:32. December 11th, 2024. And once again, I spent all day replying to the dishonorable Frank Gray. So let's go over these so you guys can see them. And 3 responses. So, defendant's motion to quash capias, request ADA accommodations, demand for legal counsel, enforcement of speedy trials. This is all stuff I've done before. I've done it multiple times. And they vacate stuff and they deny stuff because they don't want to give me a trial. And if anyone's got any questions about why they're doing this, been targeted by the Pasco Sheriff's Office for many years, and due to the fact that my trustee swatted me consistently, and they went right along with it. And it hasn't stopped since. It's as simple as that. It's hidden money. My mother's a crook, and she hired the Pasco Sheriff through one free phone call, or three or four of them. Nobody knows how many times she's called on me to have me taken out. The dead beneficiary don't cost any money. You don't have to pay them benefits. But anyway, comes down to the defendant, Tasha Teeling, pro se, and respectfully, files this motion to quash the capias issued against her, request ADA accommodations, demand appointment of legal counsel, and enforce her right to a speedy trial and support there. The defendant states as follows. And I double spaced it for him, too. This is going to be a long one because there's 3 of them. This is the longest one. Introduction. The defendant's been charged with a first-degree misdemeanor stemming from an alleged incident on March 19, 2022. Despite nearly 1,000 days of proceedings, she remains unrepresented, denied access to reasonable accommodations, and subjected to repeated violations of her constitutional rights. The court's refusal to address her motions, its striking of valid motions, and imposition of a capias in these circumstances reflects systemic prejudice and a denial of her rights to a fair trial under the 6th and 14th Amendment. Don't think they care about the Constitution, the Bill of Rights. It doesn't matter to them. They don't care about it. It's a court. Why would they care about it? Court of law. They don't care about the law. The defendant suffers from multiple documented disabilities, which have been brought to the court's attention. Due to the court's history of retaliation and misuse of such information, she's rightfully concerned about further disclosure being used prejudicially against her. They charged that was incompetent. Twice. They tried to hire this, whoever they're in cahoots with, just like the lawyers, hire a psychiatrist to do an invasive medical procedure on me. Twice. I probably found and sourced them right over the local lodge. The continued violation of her rights, including indefinite delays and punitive actions such as the issuance of a capias, constitute cruel and unusual punishment, extrajudicial punishment, and unlawful detainment in violation of the 8th and 14th Amendments. Motion to quash the capias. The capias issued against the defendant for failure to appear is punitive and unwarranted given her disabilities and lack of legal representation. And the defendant resides over 1,000 miles from the court and faces substantial hardship. She's permanently disabled and chronically homeless, living in her vehicle. Requiring her to appear in person without ADA accommodations violates the Americans with Disabilities Act and principles established in Tennessee v. Lane. The court's continued insistence on in-person appearances without accommodations and without legal representation disregards the defendant's documented hardships and undermines her right to fair and equal access to the legal system. Additionally, the capias is the result of the fruit of the poisonous tree doctrine, as the initial arrest and subsequent action by the courts were tainted by procedural and constitutional violations. The unlawful actions at the start of this case have caused subsequent procedural breaches, thus invalidating all actions predicated on this flawed process. So yeah, State versus Nelson. If you look at the last video, what the court wrote to me, which I think is the prosecutor that wrote it, and then the judge signed it. It was a proposed order, and the judge said, oh, I'll just sign Frank I. Gray here. Or Frank Gray, whatever he wants to call himself. Can't spell his own name half the time. So yeah, the court emphasized the importance of ensuring procedural fairness, including allowing reasonable accommodations for individuals with disabilities. Fruit of the poisonous tree doctrine, establishing Wong Sun versus United States, applies here. The subsequent actions arising from the tainted process are invalid. The Sixth Amendment ensures the right to confront charges in a manner consistent with fairness and due process. Florida Rule of Criminal Procedure, which addresses pretrial release and detention, supports quashing a capias under circumstances where procedural fairness has not been met. Request ADA accommodations. Once again, request them often. The defendant has made multiple requests for reasonable ADA accommodations, including appearing remotely via Zoom due to physical and logistical hardships. They want me to appear in person. They don't want to lift this capias. They want me to appear in person so they can throw me in jail. They will throw me in jail. I put my life on it. And I won't have a lawyer, and I won't be able to get out, and they'll probably murder. They'll probably shank me in jail. This is what will happen. And that's exactly what they're planning on. Chronic homelessness, while not explicitly a disability, entails disabling conditions when considering ADA guidelines and federal interpretations. Chronic homelessness is a disability coupled with homelessness for over a year. But Todd Pollard or Frank Wright, no, that's not a disability. In and of itself, that's a disability. Alcoholism's a disability. There's so many disabilities. I'd ask for a Zoom hearing. Or Zoom hearings, or telephonic hearings. Zoom hearings preferably, because you can barely hear these people. Language barriers, because I don't speak legalese. But they don't want to do that. But during the fake COVIDs, everyone, it was a, you didn't even ask for it. They'll just give you a Zoom hearing. Defendant also suffers from additional physical and mental health disabilities that impact her ability to comply with in-person appearances. These conditions, previously disclosed to counsel in the court, have been ignored or misused to paint her in an unfavorable light. Court's denial of these accommodations violates federal laws and disregards HIPAA protection, the Fifth Amendment right against self-incrimination, and the Fourth Amendment right to privacy. The right to be secure in my person. I don't have to tell these people what my disability is. They aren't my doctor. My Fifth Amendment right, I'm not telling them my disabilities. It'll create a public record for one. And two, if not one, they'll use it against me. It's none of their business. They're asking for a Zoom hearing. And plus, I live 1,000 miles away now. Driving 1,000 miles to 30 different pretrials? These people are nuts. So yeah, the ADA requires courts to provide reasonable accommodations to ensure individuals with disabilities have full and equal access to proceedings. Tennessee versus Lane. And you can see, it was either Todd Pollard or Frank Gray himself. I thought it was Frank Gray himself. I've been citing Tennessee versus Lane. Here's a quote. That's a physical disability. But these people, they have mental health courts and stuff. They'll diagnose you with all these mental instabilities and send you to the funny farm for the rest of your life. And they aren't even doctors. They got no license to practice medicine. None of these people are licensed to practice medicine. And they don't have my consent to do so, even if they were. They're not my doctor. HIPAA regulations protect individuals from being compelled to disclose protected health information in public records. It's a fact. It's been beaten in our heads for decades now. In Olmstead, the court highlighted the necessity of reasonable modifications to avoid discrimination. I'm not asking for I'm asking for a Zoom hearing. Half the time, I don't even have internet or phone service. The Florida Rules of Judicial Administration mandates reasonable accommodations for individuals with disabilities participating in court proceedings. So, demand for legal counsel. They're saying I forfeited my right. If I had money, if I had my trust fund they didn't block me from, or I had a job, I would have never been in the situation to begin with, but I could go afford some crappy-ass lawyer. But no, because I'm poor, I don't get legal counsel? So they said, I'll get in this. I'm not going to... This is going to be long as it is. If you have any questions, you can put them in the comments. Any statements, concerns, whatever. And the court's claims that the defendant forfeited a right to counsel is unsubstantiated. No evidence exists of threats made by the defendant, as alleged by attorney Justina Rosales, who recanted her claim and admitted it was based on hearsay. Anonymous phone calls they've told the court about, they just ignore it, like you never said it. Where are the police reports on that? Did you say I made threats? The court's saying I made threats to all of them. Well, there should be 12 separate police reports. And threaten them how? Did I threaten to kick their puppy? Did I threaten a bar complaint? Did I threaten to piss in their Cheerios? Did I threaten to have a temper tantrum in court? What is this threat? Like, you look at my mother's motion, said she got anonymous phone calls saying she would be threatened if I got any money. It was something to that effect. It's bizarre. I told the court about that too. They don't care. They'll just run with whatever. It's a court. They don't care about evidence. They don't care about the law. They don't care about evidence. There's the gatekeeping. And there's freaking strong-arming you. It's not a real court. The defendant's right to counsel is protected by the 6th and 14th Amendments and reaffirmed Gideon v. Wainwright. Denying this right without evidence violates fundamental due process. They don't care about that. The defendant has had 12 court-appointed attorneys, many citing irreconcilable differences or unsupported conflicts. The court's failure to appoint successor counsel reflects systemic bias in an attempt to deprive the defendant of adequate representation. Exculpatory evidence submitted by the defendant, including documented injuries showing that she was a victim, have been ignored. This failure further underscores the denial of a right to effective representation in a fair trial. Every attorney, since Pamber Smatwell, has seen the jailhouse records from a nurse saying I had bite marks and bruises, human bite marks. The judge has seen it. The prosecutor's seen it. They just pretend it doesn't exist. It's not about evidence. It's not about law. It's about covering up for the Pasco sheriff targeting people. They want to be part of their racketeering influence criminal organizations, criminal and corrupt organizations. And this court's part of it. And I'm not the only person they've done this to. They have ruined lives. The Pasco sheriff, in collaboration with this court, has destroyed people's lives. Destroyed families. Just destroyed lives. The defendant has 12 court-appointed attorneys, which are many citing irreconcilable differences or unsupported conflicts. The court's failure to appoint successor counsel reflects a systemic bias, exculpatory evidence. All right, so Florida rule or Florida statute mandates the public defenders be appointed to represent indigent defendants in criminal cases, ensuring their right to legal representation is upheld. But how am I indigent? I got a trust fund. I had a trust fund until 2021. From 1998 or 1999 to 2021. That I didn't know about. I lose my house with a trust fund? A homeless trust fund kid? But they've claimed I'm indigent. How is that possible? I never even applied for indigency status in this case. Legal basis. The right to counsel is fundamental to a fair trial, as articulated in Powell v. Alabama. Court's failure to address exculpatory evidence violates due process protections. Brady v. Maryland. Strickland v. Washington establishes that the standards for effective assistance of counsel, which has not been met in this case, and I went into great detail on that in a prior motion, that they either denied or struck from the record. Oh, I think we get into that later. I was going to talk about it, but it'll be talked about down here. And defendant's demand for a speedy trial filed appropriately under Florida rule of criminal procedures has been ignored. They said, oh, it wasn't clear. It was a demand for a speedy trial. It's not clear that I wanted a speedy trial. It's a demand for a speedy trial. And I cited all the criminal trial procedures. We don't know if they really meant that or if they're prepared. We don't know. We're just going to ignore it. We're going to ignore criminal trial procedure, which I said because it's a criminal court's not going to follow criminal trial procedure. Not a real court. The court's claim that the demand was insufficient is meritless. The motion met all procedural requirements and cited relevant case law, including Barker versus Wingo. Over 950 days have passed without resolution. I think we're like at 1,000 now. Maybe more. During which 4 jury trials have been scheduled and canceled. These delays violate the defendant's Sixth Amendment right to a speedy trial and result in significant prejudice. The Constitution of Florida guarantees the right to a speedy trial, which has been systemically violated in this case. Doggett versus United States. Court ruled that excessive delays can result in the violation of speedy trial, even without the defendant's explicit objection. I've been barking my head off. And I've been putting it in writing. We don't know if that's a thing. We're just going to keep on doing what we're doing over here. Not a real court. So yeah, criminal trial procedure in Florida governing speedy trial outlines the requirements and protections afforded to defendants, all which have been disregarded in this case. This is good right here. It's all good, but like nothing about this whole case is good. Judicial prejudice on striking motions. The court's decision to strike the defendant's motions as unauthorized pro se filings is erroneous and supported. They said because I had a lawyer that took months to withdraw, the 12th one, months to withdraw, that I didn't say there was a conflict there. But attorney Marie-Louise Mabry's motion to withdraw explicitly cited irreconcilable differences demonstrating conflict. Irreconcilable. They cannot be fixed. There's a conflict right there. Doesn't align with records. This court's action reflects a pattern of judicial prejudice, including the denial of ADA accommodations, the refusal to address valid motions, and the imposition of unreasonable burden of the defendant. The defendant's motions include valid legal arguments and evidence of systemic issues in the handling of her case. Striking these motions without merit demonstrates bias and a failure to ensure due process. The Florida Rule of Judicial Administration provides guidance on the disqualification of judges for prejudice, which is applicable in the scenario due to demonstrated bias. And that's another one he struck. There was a motion of recusal, a motion to change venue, a motion to sanction attorneys for misconduct. No, strike that, strike that, strike that. And I had this guy on tape. I got him on tape saying he had gladly recused himself. Back in the days of Serbo Simeone. He's a liar. Should have stepped down right then and there. But Serbo may have a bench trial with this guy. You'd have to be crazy to go with him. I don't want to be anywhere near this guy. This Frank Gray guy. And judicial impartiality is a cornerstone of due process. The refusal to address motions is the strikings of valid filings without basis undermines the defendant's right to be heard. Violating the 14th Amendment. Caperton versus 18 Massey Cole highlights the need for judicial recusal where bias is evident. It's absolutely evident. So I respectfully request this court. It's not a real court. I don't do it respectfully. They're not real. How can you respect these people? Quash the capias. Grant reasonable accommodations. Appoint successor counsel. Force the right to speedy trial and set an immediate trial date. The speedy trial is up on Friday. I put the demand for a speedy trial. It was like October 15th of this year. They had 50 days. They just ignored it. And I sent them a notice of expiration of speedy trial. And they have 10 days after that, which will bring it up to the 14th, which is Saturday. So they have till Friday. Address and rectify patterns of judicial prejudice. Let's go back here. So that was the motion in response to denial and strikes. And I had to do a habeas corpus. So it comes down to the petitioner touched detailing pro se. How could I be pro se? I never went to law school. Pursuant to Article 1, Section 13 of the Florida Constitution, 28 U.S. Code, subsection 2241, respectfully petitions his honorable court for writ of habeas corpus. In support thereof, the petitioner states as follows. This court's jurisdiction to issue a writ of habeas corpus. It doesn't have jurisdiction because it's not a real court. But the way they're pretending, they should have it. Habeas corpus is appropriate to challenge unlawful detention, including issuance of a capias, denial of counsel, denial of ADA accommodations, and violation of the constitutional rights. Petitioner has been charged with first-degree misdemeanor. Capias was issued for failure to appear. It's improperly issued. Petitioner has been denied legal counsel, reasonable accommodations, speedy trial, direct violation of rights under the 6th, 8th, and 14th Amendment. Unlawful detention of the capias. The capias was issued against the petitioner constitutes unlawful detention because it arises from a failure to appear. It was directly caused by the court's refusal to grant ADA accommodations or allow remote appearances. Plus, I've asked every attorney to waive all my pretrial appearances. I can't be there. I can't go to 30 pretrial appearances. Nobody will want to. And they failed to do that. Dude, it was ineffective counsel because they're all in cahoots. All these judges and lawyers, they all get together and they figure out how they're going to screw certain people. The whole country's been it's been totally subverted by a bunch of ambulance chasing attorneys. Every single, you name any politician in your area, go to your state bar and look up their name. You'll get a bar card number, you get their contact information. They've taken over the whole country. Right under your noses. Yeah, the capias is punitive and violates the petitioner's due process under the 14th Amendment, as well as her right to pretrial liberty under the 8th Amendment. For the poisonous tree doctrine, establishing Wong Sun again, applies here because initial arrest and subsequent capias were tainted by procedural violations of constitutional infringements. You can go watch the arrest. I never got questioned. I never got Mirandized. They shut their body cams off. They were going to arrest me no matter what. We can't get her for battery. We're going to get her for voyeurism. Sickos. So Pasco Sheriff, they're all over the news once again. Over their ILP program, and they're targeting people. All over the news. Right in the news right now. Petitioner has 12 court-appointed attorneys withdraw, many saying irreconcilable differences and unsupported conflict. The court failed to appoint successor counsel, leaving the petitioner unrepresented. Denial of legal representation violates the 6th and 14th Amendment rights. No evidence has been presented to substantiate allegations the petitioner has forfeited her right to counsel. Claims of threat made by the petitioner were recanted and remain unsupported by police reports or credible evidence. I have that tape too. She said she got an anonymous, and they didn't name that in the motion or the order. The judge says, the prior attorney said that I was making threats. And I have that tape. And they're mad that I taped too. They said they got an anonymous phone call saying I threatened her on my YouTube. Where? Where is it? And he said, did you call the cops? And she said, it was Jacinia. She said, no, I need to have evidence to do that. She had no evidence. And I got that on tape. And it's on here. It's in my legal playlist. You can listen to it yourself. So yeah, claims of threat by the petitioner were recanted and remain unsupported by police reports or credible evidence. Violation of ADA rights. Refusal to provide reasonable accommodations. Denial of a speedy trial. Judicial prejudice and unusual punishment. So yeah, the court's action includes strike invalid motions, denying motions, requiring in-person appearances despite documented disabilities reflects systemic bias. The cumulative effect of these actions amount to cruel and unusual punishment under the 8th Amendment. It is nobody should have to endure a trial for 3 years with no end in sight. 3 years, 30 appearances, at least 20 days in jail. Can't even go back to Florida because I'll be arrested and thrown in jail again. It's cruel and unusual. And it affects me. Like, what if I went to apply for a house? I can't pass a background check? None of that shit now. No, you gotta wait, Cookie. Yeah. So I asked this court. Hold on. It's freaking animals. They always need something. Yeah, so I asked the court to issue a writ of habeas corpus, quash the capias issued against her, and release her from any associated detention or restrictions. I'm asking this stuff for like the 3rd or 4th time. They will not listen to it because everything's based in law. They don't want anything to do with law. They don't want anything to do with the Constitution. None of that. It's not a real court. I put my life on it. Order appointment of legal counsel. They don't want to do that. Mandate reasonable ADA accommodations. I'm not asking for much. I'm not asking them to put a frickin' wheelchair lift in the friggin' courthouse. I'm asking them to do a Zoom hearing. And a tard could set up a Zoom hearing. I'm not asking for anything unreasonable. They want me there, in person. They're going to drive 1,000 miles in person so they can arrest me, throw me in jail where I'll sit and rot until they set up somebody from the lodge to come and shank me in cell block D. And then, oh, problem solved. I'm not falling for it. I'm not that stupid. I told everybody when I did that deemed a slave video that this is exactly what they were going to do. That they were going to say I abused attorneys. And that's exactly what they did. I know what these people are doing because I've been studying law for 10 years now. Because I've had to deal with them for 10 years. 2014, my trustee started swatting me. And I had to deal with these cops in the same court, the same judge. I know everything about them. Know your enemy, know yourself, know these idiots, these a-holes. You'll probably be alright. So yeah, enforce a petitioner's right to a speedy trial and dismiss the charges. And dismiss the charge. They should be dismissed by Friday, but they're not going to do that. That's part of criminal trial procedure. Demand a speedy trial. They either give it to me or the charges must be dismissed. They're going to ignore criminal trial procedures. Just like my civil case. That's a whole nother story that I've already covered. Civil trial procedures fall into a T. Court says, no, we're not doing that. We don't do that kind of stuff. We don't do that. And then finally, went ahead and did this. Let's see how this works out. Defendant's motion to request Judge Frank I. Gray II's oath of office and bond. I want his bond. I want his oath of office. I'm probably going to have to go after his bond because I've already called the Judicial Qualifications Committee. You'll never hear from them. Never hear from them. Gonna have to go after his bond. Comes now me. And I asked to provide copies of Frank I. Gray's oath of office and bond. In support of this motion, the defendant states as follows. I'm charged with this to maintain transparency and ensure judicial integrity is necessary to verify that all judicial officers presiding over the defendant's case have properly taken their oath of office and are appropriately bonded. People have been caught, judges have been caught that aren't even real judges. I know this guy's not a real judge, not a real court. But there's judges practicing without even having a valid oath and not bonded. So yeah, according to Florida statutes, all public officers are required to take an oath of office before commencing their duties. The oath must be filed with the Secretary of State. Bond requirement. In his of the certain public officers provide a security bond. So he's got to be bonded. It's like being insured. I'm going to revoke his bond. He revoked my bond. I'm going to revoke his bond. So yeah, under Florida public records law, good luck. I can never get a public record ever. From frickin' Florida to Arizona, Pasco sheriffs to whoever, they will never fulfill a public records request with me. Let's see if this guy gives it up. He's bound to. He has to. Request for office and bond. The defendant requests his honorable court provides copies of Frank I. Gray's oath of office and bond to ensure compliance with statutory requirements. These documents are essential to verify that Judge Gray has met all legal prerequisites to preside over this case and to affirm the integrity of the judicial process. There's no integrity here. Even if this guy's got a valid oath and a valid bond, there's nothing. There's no integrity in him. None whatsoever. But yeah, that's pretty much it. So that's where we stand now. We're going on 3 years. 3 freaking years of this crap. Saying I touched this kid's shoulder. I touched the kid's shoulder, they say. And I'm covered in human bite marks and bruises. And Donna says I'm dragged all over the living room by my feet. 6 cops show up. That don't Mirandize me. Haul me off to prison for 20 days. It's all this stems back to Patty. Freaking Patty and her damn trust fund. Her super secret trust. What a scumbag. She's destroyed this family. She should have left. She's never been... She just took off. But no, she's got to ruin everyone's life. She's a total sociopath. And now she's... I see the way God works. And I know why this happened. And I know what's going to happen. I know the future. See you guys later.